Or of him, Mamma, about the modern on TV, so a basis of like and subscribe. Now, I don't share about comment section or now. Now, you are a high court, court transfer. Now, or the Supreme Court in Sema or catcher and say, Uncle Transfer. No sanity endis for in Sema whatever. On sanity and on ye one the open amount now. Oko transfer no was and valid number and a valid number no nature say. Once I am my NPP beam mandomos application no high court say I approve my NPP say easy inko. That's a 4 constituencies now can once and regulation no. And end this where I take quick action against that. I just say one penny grab because I think say still no say easy ama one finance and one regulation. I just say end this phone. Court our coin won't be aware but still
your party was not duly heard.
We were heard on an issue of mandamus. We were not heard on the substantive issue of what transpired at the collation center. It has nothing to do with that. The writ and the affidavit attached to it. If they were asking us to now come and defend on the issues, we would have asked them to come and we'll cross-examine them.
Is that not changing the case into a full election petition?
That is what he has done. He has ruled based on the full blown of the matter. So why should we expect as a party, NDC, to allow this kind of charade to continue? We are not going to accept it. We have filed a process. Nobody is going to do any collation whatsoever at that place. We are telling them we will not accept it. We are going to resist it. With all the legal powers that we have, we are going to resist it. We have done the processes and we are telling them the easy. They should stop being lawless. If they do anything lawless against us, we will come after them.
Well, two important.
What is your initial reaction?
Oh, like I said in court, you can only oblige what the judge has said. But I must say that it is something that we anticipated. So we came to court prepared with our notices of appeal. And as you can see, immediately the judgment was read, we ran to the registry of the court to file the respective notices of appeal in respect of the 4 affected constituencies, as you can see. So with us here is the notice of appeal and the subsequent stay application. It is something that we knew was going to happen. With the ruling on the prelim, it was clear where the judge was going. And so we took preemptive steps to do what is needful. So I can tell you, and as you can confirm here, we have the respective notices of appeal. We have them here, and we'll take steps right now to get them, the legal requirement. The order must be served on the Electoral Commission before they can proceed. And like my lord said, they are now working on the order. We have our stay application, we have the notice of appeal, and we take steps. This matter is not ending here, and let nobody be deceived. This matter cannot end here, because you see, the matters raised, and if you are in court, it was as though my lord was hearing an election petition. This is a mandamus application, for Christ's sake, and that is all that I will say. So we'll take all the steps.
But time is also running out. Time is running out. How are you dealing with the issue of time?
No, first of all, the court itself said because of the election and the nature, expeditious trial will be permitted. And we have taken steps timeously. Look at the time the judgment or the rulings were delivered, and look at the time we filed our respective notices of appeal. That is the speed with which we want to do it, and we have taken all the necessary precautions.
Thank you, Honorable. But let me speak to some of the candidates speaking.
The evidence before the court in respect of Tema Central, uncontroverted, was that it was not the case that, as alleged by the applicant, that there was no collation. Indeed, there was a collation and a declaration. But that out of 148 pink sheets, 146 were collated, save 2 that the NDC opposed. Now, we opposed those 2 pink sheets on grounds that they were fabricated after the close of polls on December 7th at 5 p.m. Now, we invited the presiding officers in respect of those 2 polling stations. They came to admit that when the polls closed, they were tired, they were exhausted. So they brought the pink sheets to the office of the EC. And and they were instructed by their EC Metro director to complete them. How do you complete a pink sheet in the office of the EC after polls have closed?
Were you giving copies of these?
They gave us a duplicate. The duplicates, therefore, the duplicates that we had, the pink sheets in dispute. I want everybody to appreciate this matter today. The 2 pink sheets in dispute in Tema Central, the duplicates that we have, that was how I was able to detect it. The duplicate did not contain the information contained on the original that the EC was urging upon us to approve. Why? The duplicates that we have did not have the name of the presiding officer, his signature, the year of the elections, and the time of close of polls at the polling station, and date. That is the year of the election. That's the date. This was a requirement in pursuance of Regulation 43 of CI 127 and Regulation 3923 of CI 127.
You have a right to
Hold on. So we disputed. And they were insisting that it should be admitted. This was what generated the entire controversy. Today, so if the court says, in view of all this, by a mandamus application, go and collect it, do you think me, the farmer, I will agree that those 2 pieces be collected when they are in dispute? It is not a mandamus that will correct it. It is a full-blown trial, so that the person who deposed to affidavit that the pieces were in dispute, who will be put on the stand. Then I'll cross-examine him that you have admitted that the pink sheets were completed, for instance, in your office after our agents, the polling agents of all the contestants have left. So the law does not permit you to complete pink sheets in your office and come and give to candidate to accept.
So, Honorable, obviously you disagree.
Of course we disagree.
What's the way forward?
I think we advise ourselves, and I'm sure by the close of the day, you know the position of the party in this matter.
You have less than 2 days to go.
Yes, I'm saying we are working today, Saturday. Right now, where we are, tomorrow is even material as a non-working day. We can be working tomorrow. So by close of today, the party's position in this matter, you will be advised and you will know. But this is not the end.
This is Tema Central. Would you throw some more, share some views?
In fact, if we were in court, the court appears to be rehashing the same facts in respect of all the other respective constituencies. So, for instance, Techiman South, the judge mentioned 62 pink sheets, when indeed that was not the issue in respect of Techiman South. Okankwe Central, there were not 62 pink sheets. The judge was mentioning 62 pink sheets. So why? When you write a ruling, who corrected him? Gary Numaku corrected him from the bar. Do you stand at the bar and correct the content of a judgment being delivered by a judge? You bring an application on notice for correction of judgment in terms of facts.
Couldn't it be understood?
It could not. It could. Please. I will not go on that path with you. I am saying that where a lawyer stands at the bar and be correcting the content of a ruling delivered by the judge, we have a problem.
Party which speak to the constituency organizer NDC for Ablekuma North, who wants to share some thoughts with us on the constituency. You are certainly not excited about the direction the court has taken.
Yes, I'm not happy, but I'm not surprised. Since yesterday, even right at the constituency, we had the NPP supporters giving us the verdict that will happen today. And early this morning, your reporters and the cameras are all here. They keep saying all the polling stations will be recollected. And this is exactly what has happened. And I want to put on record, we've also picked intelligence that as we speak, Bosman and Demensa are trying to start their illegal reconciliation as we speak to you. It's an intelligence we've picked, and we are sending a strong warning to them.
Yes. When you say start illegal collation, court has given an order, and I'm sure that that order is going to be followed through with. At this point, there cannot be any such thing as an illegal collation following the order of the court.
Thank you, my brother. This is not the first time an high court has given this verdict. It happened the last time. We went to the Supreme Court, and the Supreme Court said it was illegal, it was quashed. And I'm telling you, this ruling will also be squashed.
You will be going to the Supreme Court?
I'm telling you, our lawyers are at work. That is why.
But the court has observed that some 52 or 62 polling station results had not been collated. I don't think you would admit that without the outcome of those 62